This is regarding the 301st Judicial District Court in Dallas County, Court of Texas, in the matter of the marriage of my wife and Jeffrey Stephen Morgan, case number DF-25-09534. The Honorable Ken Paxton, Dear Honorable Ken Paxton, I, Jeff Morgan, pro se respondent in the suit, hereby files this notice of constitutional challenge regarding Texas Family Code 6.001 with supporting memorandum enclosed in compliance with the Texas Government Code 402.010. The statute in question establishes insupportability grounds for divorce, also known as unilateral, quote, no-fault divorce. 6.001 confers absolute entitlement upon every petitioning spouse to obtain dissolution of marriage for any reason and for no reason at all. And what's important about this is when you think about the way that bills become laws, there's a process. The bill gets submitted, it gets read, people debate it, they may make changes to the bills and stuff like that. Then they vote it out of committee, and then they have both houses have to vote on it. It has to be read a certain number of times. And if it receives the requisite vote, then it goes to the governor's office, and the governor has to sign it into law or has the opportunity to veto it, which he does. Then it can be overridden by so many people within the House and the Senate that they can override the governor's veto. No-fault divorce, insupportability, becomes a self-executing law. I say something is insupportable, my way will prevail no matter what. When we have bills that become laws, there's a big process. When you enter divorce court and somebody says, I'm pleading insupportability, that becomes a law. He or she becomes a law unto himself or herself, and the law becomes self-executing. My personal desires become the law, and my personal desires get executed by the judge who is, quote, following the law. This is a travesty of justice. Continue back on this again. 6.001 confers absolute entitlement upon every petitioning spouse to obtain dissolution of a marriage for any reason and for no reason at all. Courts across the country acknowledge there are no defenses to no-fault grounds, as they are based on, quote, a subject state of mind. So whoever is presenting it, whatever he or she believes now becomes the law. And this has been discussed in many cases throughout the entire country. So this is the idea is that no fault, you don't have to have any type of grounds, but you can unilaterally impose divorce upon your spouse for any reason, for no reason. You can make up a reason. What is constitutionally problematic about the statute is that it operates without regard to fault and inevitably results in divorce actions without establishing default or mutual assent. So in other words, if I'm in breach of some type of marital duty, or my wife is in breach of some type of marital duty, we should be able to get to go to the court, and the court should be able to say, you know, Mr. So-and-so or Mrs. So-and-so, you are in breach of this duty. Now, I'm not saying even with that a divorce should be granted, but there are some standards in which we almost consider certain actions to be egregious, and that these actions can constitute a valid reason for divorce. By the way, conflict of personalities and discord is not really even a ground for divorce. So they've tried to say, well, it creates such an environment that, you know, it makes the legitimate ends of the marital relationship not able to be achieved. Discord and conflict of personalities will exist in every single marriage. And this is not just the normal discord that we have in everyday life. So if my wife and I get into an argument, I can't say, well, if you're not going to listen to me, I'm going to file for divorce. And she can't do the same thing to me. That is something that in our marriage, we will know that there are conflicts that will take place, and that conflicts and even differences in personalities are not a cause for divorce. But the statute is saying contrary, and it adds some gobbledygook, which appears to be so nice, but really it's not. It's actually blatantly false. So it results in divorce actions without establishing default or mutual consent. And once again, people who get married, it takes two people to get married. It takes two to tango. It takes two people to get married. There's a mutual assent. In fact, there are provisions in which there is a forced marriage that you can actually say, look, I was married against my will. I didn't know this. I was drunk. I was underage, whatever. And that could be a reason for the marriage to be dissolved. But when two people are older, both in a solid state of mind, they choose to marry each other, they enter into a bilateral commitment, covenant, contract. Two people do it together. One person does not get to unilaterally dissolve a contract in any type of a situation except in marriage, except in the Texas Family Code. And I will talk later on about how this is actually a very planned program that was put into place by the divorce attorneys, by feminists, by a number of other people to destroy marriage, to destroy families. I'm not going to get into that right now, but that will be brought up later on. So anyway, the whole thing about unilateral no-fault divorce, insupportability, without regard to any fault, you can have a divorce for no reason whatsoever. It violates numerous constitutional principles, such as the contract clause. The Dartmouth exception applies where no default or mutual assent exists. The Dartmouth exception goes back to a case in 1819, I believe was the year. The religious establishment / conscience clause. So the legitimate ends of the marriage is a religious question. And this is what Justice Kem Thompson Frost discussed in 2001 in Waite versus Waite. That when we talk about the legitimate ends of the marital relationship, how do we know what that is? My legitimate ends may be different than yours. And she used the example, I believe, of Christmas. Like at Christmas time, you know, some people have the birth in the manger of Jesus Christ, the star and everything, because to them, the purpose, the legitimate ends of Christmas is to remember the birth of our Savior, Jesus Christ, who came into the world to die for us, to redeem mankind from sin. Now, other people who don't accept that religious connotation may say, well, no, this is just time for family to get together. We have Yuletide, we have Rudolph the Red-Nosed Reindeer and Frosty the Snowman and Santa Claus. That's fine. Cities often have a commingling of the sacred and the secular together. But as long as there is that sacred aspect of it, the legitimate ends of the marital relationship, the court is not allowed to actually opine or violate my rights of conscience with regard to my purpose of marriage and the legitimate ends of the marital relationship. I believe as a Christian, by entering into marriage, it was something that God called me to, and it was something that he took two imperfect people, very imperfect people, and he was going to have the two become one. The two would be better together than separate. The two would learn how to love each other, how to forgive each other. So by the way, in the Bible, in many instances, the marriages were arranged. So it was not like the American scene when you get to date somebody for a year or two and check them out, and are we compatible with this? Are we compatible like that? In many instances, and throughout the world still today, many marriages are arranged. So this is actually dealing with issues like arranged marriages as well. The two people can come together and they can have wonderful marriages. And I know I've lived in the Middle East as a missionary. I've talked with people, friends that are Palestinian that are here. One of my good friends, a mechanic, Palestinian friend. I don't even believe he met his wife until the day they got married. And he said, yeah, the first year was hard. And then he tells me how much he loves his wife. And they have a great marriage. They have a marriage in which they've committed to each other. And God works in their marriage. And by the way, they're not Christian, they're Muslim. So this is not just a Christian issue, it's a Muslim issue. It can be a Jewish issue. It can be many religions throughout the country, throughout the world have the same issue, that marriage is something that is honorable and sacred. I've spoken with people from Africa as well, and they said, oh no, marriage is very, very sacred. And if there are issues that are there, the village elders will get together and they will make sure that these two people will work things out. Adultery is not an option. Leaving each other is not an option. The marriage must remain intact. So anyway, again, this is a religious issue, the Texas Religious Freedom Restoration Act. That's a very big deal. The government has to show a compelling reason as to why my marriage should be dissolved. It's got to show a compelling reason, and it has to also prove that the way that they're doing it is the narrowest means possible. Strict scrutiny applies. And this is, again, in the Texas Government Code 110.003. The speech clause. Insupportability is an ideological question, and the person who says that something is insupportable, the state will always, without question, support the insupportability determination. In other words, the state has a predetermined bias toward insupportability. If somebody utters the magic words or writes them down or says insupportable, blah, 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 the state will say, divorce granted. And that creates viewpoint discrimination and speech discrimination based on my ability to say, I protest, I do not agree that the marriage is insupportable, I believe that the marriage is completely reconcilable, and that we can have a marriage that glorifies God. Separation of powers, the predetermined outcome. The courts adhere to a legislative dictate. And once again, the legislature is not allowed to grant special laws creating divorce, and yet I have judges on record, Judge Brett Hall of the 354th, I believe it is, in Rockwall, Texas, who told me that I have to follow the law. The legislature has done this. And so basically what he's saying is that the legislature has created this law that automatically grants divorce when our Texas Constitution, Article 3, Section 56.13, says that it's impermissible for them to do so. Equal protection. Petitioners always prevail. If two people are party to the same marriage, there are supposed to be equal protections under the 14th Amendment. However, when it comes to divorce, the petitioner always wins on the merit. The respondent always loses. How can you say that? Because the petitioner will always get the divorce. That's what is at hand. Now, they may want to get more money, they may want property, they may want this or that. They may not get the best settlement that they want to, but they get the divorce. They get to force their spouse to change his or her marital status from married to either divorced or single. And by the way, when you're married, there are a load of benefits, over 1,100 benefits at a federal level that you accrue just because of being married, and multiple other benefits at a state level. This was part of the reasoning behind the Obergefell decision in 2015, and Justice Kennedy said that marriage bestows, quote, a constellation of benefits. And how can we deny this constellation of benefits to people simply because they're the same sex? How can you take these constellation of benefits from me when I have committed no legal infraction simply because my wife or another person's husband would say, I think it's insupportable? This is completely unconstitutional. Subject matter jurisdiction. And what the statute says is that without regard to fault. When you appear before the court is supposed to rule about your conduct, not about your beliefs. The court is not supposed to say, well, Mr. Morgan, you have the wrong belief about these things. I'm sorry, the courts are not allowed to do that. We have protection of our free speech, protection of our opinions. And what they can do, though, is say, well, Mr. Morgan, I see that you went across the street and you did this and this and this, and you committed this crime and that crime and everything else. So therefore, we are going to find you guilty of something. We're going to punish you. We're going to take away your freedom or whatever. But when a legally unimpeachable person goes in front of a divorce court, they still have no defense. And the courts actually have no subject matter jurisdiction because one person is saying, I think it's insupportable. What have I done? Well, without regard to fault, you don't have to do anything. That judge can sign a decree and divorce you, change your marital status on the basis of your spouse's assertion that something is insupportable, with no idea of what that means, and with no proof, and with no test, and without having to make any efforts to try to make it reconcilable. And then the public policy issue in 6.001 constitutes a private ordering of divorce. And marriage is a public policy. Marriage is not just a private issue. It also has societal benefits. So the society at large, the public at large, has benefits and has interest in seeing strong marriages. When you have no-fault divorce, unilateral no-fault divorce, insupportability, you have created that one person can take his or her wishes and elevate that against public policy. So anyway, those are the reasons that we are saying that 6.001, and when I say we, I am the petitioner here against the state. I'm respondent in the divorce court, but I'm also the one who is telling the Attorney General that the statute is blatantly unconstitutional. While several of my individual rights are likewise implicated, these above-cited constitutional violations are structural in nature and strike at the heart of legislative and judicial power. And as you've noticed, a couple of things that I've mentioned, yes, they are personal, but the reality is this statute is structurally impermissible. As Justice Kim Thompson Frost said in 2001, there is no way that you can reconcile 6.001 with Texas jurisprudence and the constitutional protections that individuals should have, right of conscience and other such things. So I am seeking declaratory relief proclaiming 6.001 to be facially unconstitutional and void. I am being taken to court based on 6.001. The judge wants to make a determination on me, and I said, the statute is unconstitutional, Judge. With all due respect, you must dismiss this motion because you have no subject matter jurisdiction. This statute is unconstitutional, and you are divested of any subject matter jurisdiction. This case must be dismissed. And district court judges actually do have the ability to do that. They don't have the ability to change the whole statute, so this might have to go through an appellate process, but the judge should still be able to look at the arguments and answer them and say, I have no subject matter jurisdiction, and dismiss this entire lawsuit. I would greatly appreciate your involvement and thank you for your consideration of this matter. So this was sent to Attorney General Ken Paxton. It was CC'd to Dan Patrick, the Lieutenant Governor of the state of Texas, Charles Perry, who was the House Speaker pro temp, and also Dustin Burrows, the Speaker of the House. And then I also submitted a copy to the attorney for the petitioner, who was my wife. And once again, I signed this. But this is in essence, my constitutional challenge to the 6.001 of the Texas Family Code. Now, what I plan to do is go over each of these points. As I mentioned, there are 11 different constitutional arguments that I'm mustering here to say this statute is unconstitutional. Out of these 11 issues, all I need is one to pass, and I think all of them should pass. So if all of them passes, or just one of them passes, it's still unconstitutional. The court lacks subject matter jurisdiction.